Hello neighbor, I'm Robert Burns, and it is such a delight to come to you today. We are videotaping from the house of Miss Betty Jo Story. She is the young lady who had a hearing before the LALB on September the 10th of 2013, involved auctioneer Marlo Schmidt. We are in the town of DeRidder, Louisiana, and we are videotaping from Miss Story's personal residence. And as most of you know, there was a trial that took place today in a small claims court in the city of DeRidder. We are coming only 20 minutes after that trial has concluded, and I can pleasurably report to you that the judge handed down a judgment against Mr. Marlo Schmidt in the amount approximately of $4,109 and some odd cents, in addition to the court costs associated with the proceeding to get us to this point. And I think that would have to be considered a rather resounding victory. Judge O'Neill made it a point that this business of not reducing a client's desires for reserves down to writing is unacceptable. I think common sense should have dictated that. She did, without coming right out and saying it, did say that there was some shield bidding going on. I think that came out at trial pretty evidently. She said arguably that was the case on the real estate, but clearly was the case on some of the personal items. In fact, Marlo Schmidt made the comment that shield bidding was taking place there, but I would submit to Mr. Schmidt it was his obligation, as I had pointed out on the website, to point out that you can't bid on your own items. She wanted to set reserves. He wouldn't have that. Now, he admitted in court that she wanted those reserves after the contract had been executed. Therefore, he felt emboldened to go forward with the auction, even without those reserves being specified to writing. Not only did the judge not agree with that assessment, you can always do an amendment to a contract, and by his own admission, she wanted the reserves in there. She also disagreed vehemently with being able to, this business of charging a consignor to buy back their own merchandise, of which approximately $3,800 was involved in Miss Story buying back items of her own that she did not want to have sold, those marquee items, if you will. And so that was the basis for the judgment. Obviously very pleased with today's proceeding, and it's considerably more than the $1,300 that Mr. Schmidt admitted that he had offered in the LALB hearing. And to Miss Darlene Jacobs' credit, she advised Mr. Schmidt to go out into the hallway and work this out. Of course, as most of you would well know, and he did not deny in court today, he's made no effort to work this out. The judge asked him. They went and had a little side negotiation before the trial ever began, because she wanted to settle this thing without a trial. And she asked him, have you made any effort to settle with Miss Story since the filing of this lawsuit? And he readily said no. They went into chambers to see if they could resolve this. I'm told he made a $1,500 offer, which was only $200 higher than the previous one. But the problem here is there was never a proper accounting of what was owed in this, and the judge picked up on that rather quickly. And now, to Mr. Schmidt's credit, he said he didn't do anything intentional, and no one would assert that he didn't believe this was acceptable business practice. Now, the judge did admonish him that if he's going to continue in business, he really needs to consult an attorney and get a much better worded contract to where it is specified that the consignor is understanding that if they bid on the items, they're going to be charged the commission. That was not in the contract, and the judge faulted him for not having that, and strongly recommended, I think she gave good common sense advice. I know when I was an auctioneer, I certainly had my attorney draft the purchase agreement, the listing agreement, and it had all of the specificity in there. She heavily criticized this contract as being very vague and open to, in fact, she said at some point there didn't appear to be a proper meeting of the minds on this whole event. Now, she also advised Miss Story that before you sign your name on anything of this nature, get some legal guidance as well. So I'm just going to ask Miss Story a few questions. I know this is bound to be a happy day for you.
Oh, it is indeed, Robert.
I know it's been a long time coming, and Let me just say that, well, congratulations, obviously.
Thank you.
I really commend you on having the tenacity to stick this out. I know at the point that you completed your LALB testimony, which I thought was quite good, you were a little bit disheartened, though, at the findings of the board. And would you care to comment on that, sir?
Well, I went to Baton Rouge expecting the board to help me. I mean, they're appointed people and they're licensed auctioneers. I went down there thinking they was to help the public. Well, I sure was fooled. And I should have known one licensed auctioneer is not going to damage another licensed auctioneer.
Well, in some defense of the board, if it's painfully obvious, they will. To be fair, they will when it's painfully obvious. But I would agree with you that they don't bend over backwards. And let me just say this. I was very disappointed in the investigator. And I have a tremendous amount of respect for him. But I read his investigative report. And in that report, he explained off, because the judge questioned this business about the Robert Street house pretty extensively. And in that investigative report, Mr. Steele said that a gentleman named Gordon Jenkins, during the auction, was negotiating to buy the home from Richard Schmidt, who happened to be Mr. Schmidt's nephew, Mr. Marlo Schmidt. I'm assuming Mr. Steele didn't pick up the phone and confirm that with Mr. Jenkins, because Mr. Jenkins was called as a witness at today's trial, and he was called for a reason. Mr. Jenkins was telephoned. I telephoned him, and he said that didn't happen. Okay? And yet, in Marlo Schmidt's response to the board, he says that's what happened. That there was, during the auction, that there was discussions going on between Mr. Gordon Jenkins and Mr. Richard Smith, that Mr. Gordon Jenkins would buy the property from Richard Smith after the auction. Miss Story, with Mr. Jenkins on the stand, asked, would there have been any reason for you to have needed to utilize Richard Smith as your bidder? And he flatly said no. When I had questioned him on that regard prior to today's trial, he said to me, and I quote, "Robert, I may be stupid, but I'm not that stupid." Okay? And my question to both the board and especially to the investigator is, why didn't you call Mr. Jenkins? Why did you just take the auctioneer's word for it? And I want to tell you, the judge was more than just a little bit less than subtle in suggesting that Richard Smith may have very well been a shield bidder to get the price up. The judge was also quite condemning of the fact that Marlo Schmidt had bought that property prior to the auction at $25,000, and the settlement statement was presented to the judge. She said, and I want to quote her, "Mr. Schmidt, as you should well know, a settlement statement should track all of the funds associated with the acquisition of a property, and as a real estate broker, you should know that." She wasn't pleased to find out there was an additional $17,500 remitted long after the closing of that property. In other words, Mr. Schmidt already had legal title to the property at the time of the auction. She didn't like that, okay? And in fact, she said there are a number of things that don't look good in this whole transaction. I think it comes as a little bit disheartening that the board found no fault here. In fact, I know. It was stunning to me. Obviously, it was stunning to Ms. Story.
Yes.
And I believe it was wrong. And I don't have an explanation for it. I don't have an explanation. Now, Mr. Sims, to his credit, he did at least say this board could think something else without uttering the word shield bidding. Well, the reality is that whole board, if you have any level of competence, you ought to be thinking something else. And you ought to be posing the question, and yet not one board member during that hearing, not one board member posed the issue of whether or not Richard Smith was serving as a shield bidder. Not one. Not one. Okay? And it's just too bizarre of an incident. Like I said, the judge didn't come right out and accuse Mr. Smith of having a shield bidder in the audience, but she did say it could certainly be interpreted that way, and I believe that was her words, given the bizarre circumstances And don't forget, Mr. Jenkins got on the stand and said he never discussed purchasing that property during the auction. They did come to him afterwards, because Mr. Marlo Schmidt was not exactly a willing buyer of this property. Yes, by his own admission, he did so because Miss Story had been assured of the $42,500. Now, obviously he couldn't get that during the auction, and so he wound up buying it, but that's where the efforts to get it into Richard Smith's hands were. But I'm sorry, Gordon Jenkins' hands, forgive me on that. Mr. Jenkins said I didn't want it. He said I bid on this property up to the level I was comfortable bidding. Why would I have him take over for my own bidding? He had bid on the property. Why would he drop out of the bidding and have somebody else take over for him? It's illogical. And yet, we have a board that's supposed to delve into these type things, and nobody saw fit to answer the question. I have an hour and a half approximate video of it. Show me where anybody asked that question. There's also this issue about not reducing to reserves. Ms. Story made it clear at the LALB hearing, and she made it clear in court today, the 4 items she wanted reserves on. Why isn't an LALB member asking him, why didn't you do as she asked you to do and put reserves on those items? And I'll tell you the most damning part, Marlo Schmidt admitted in both his response and admitted in court today, he wasn't comfortable going forward with this auction. And I'm pausing there because I don't understand an auctioneer going forward with something you're not comfortable with. I don't understand it. And he said in his response that if she didn't want these items to go, the marquee items, what she ought to do is pull them from the auction. Well, that's not consistent with what her desires were. He did admit he had a fiduciary duty to her to adhere to her desires. Her desires, now he wanted to say they were communicated after the contract was signed. Days after, a couple of days after. I don't care if it was after, that's what amendments to contracts is for. And then if you're not comfortable, as he said he wasn't, he had a duty to Ms. Story to say, Ms. Story, I'm sorry, I don't believe we're going to have a successful auction. I think it's in our best interest that we both walk away from this. And I would imagine even Ms. Story would have preferred that scenario than where we are today. So I guess the moral of that is that, number one, as the judge, as we like to say, we're offering continuing education. And by the way, I think you would join me in expressing great gratitude to Reverend Freddie Phillips, the president of LAPA, who has set up this framework to assist consumers. And I know Reverend Phillips has given you moral support.
He has.
All along. Yeah, absolutely. And look, Reverend Phillips, and I know you are too, believe prayer is a powerful thing. And I really believe those prayers were answered today. And I want to say to Reverend Phillips, I know you've been through a lot. I know you've been lampooned. But I think things like what happened today validate the vision that you had in the formation of LAPA, and I am pleased to be a part of it. Now I do want to address one last thing. It's my understanding that you've also sued the LALB. Am I correct on that?
Oh, yes, 19th
District Court.
Yes.
Well, what I want to ask here is, you made an effort. You wanted to discuss this whole situation with the board. The fact that Marlo had walked past you in the hallway after Miss Jacobs had admonished him to up his offer of $1,300, and he walked right past you, and by his own admission today in court, so if he changes that, it's gonna be then you perjured yourself in court. By his own admission in court, he's never made one effort to settle with Miss Story.
No.
Okay, Miss Story submitted the LALB form for discussing this matter with the LALB, Mr. Schmidt's unwillingness to do this. When I looked at the form, it was dated approximately August the 22nd, give or take. I may be off a few days. Would you please state the response that you got? Because a lot of times when people hear it from me, it's, oh, I don't believe that. So I don't want you to hear it from me, okay? I want you to hear it from the horse's mouth. When you submitted that request to appear before the LALB to discuss all that, what was the response that you got?
Robert, I was told you'll just be wasting your time. Oh, Miss Story, you'll just be wasting your time if you come down here to Baton Rouge. It's not going to help you. I would suggest that you just wait and not come down here.
Okay, would you mind just turning, I want to make sure they've seen you looking into the camera. I know you looked at me, but
Oh, okay.
I just want you to say what you got told.
I was told by Sandy, don't bother to come down here to Baton Rouge. You're going to be wasting your time. You're going to be wasting your time, Miss Story, if you make the trip down here to Baton Rouge.
So that's what she was told, and realizing September 10th was the date of prescription, she then said, I want to proceed forward with suing the LALB because I believe in their failure to find him guilty. He didn't reduce her requested items to reserves. He had a fiduciary obligation to do that. He didn't do it. Okay, Ms. Jacobs did cite that in the end, but she refused to find him guilty of any auction violation. Ms. Dow, if you go back and look at the video, said she believed there was, quote, clear deceit here. And she left it to the board's discretion of whether they wanted to go to the next level and say that there was incompetency or gross negligence. She said, I'll leave that to the board's discretion. But she said there was clear deceit here and the auction should have been conducted in a very different manner. Now, Lord knows I have been critical of Ms. Dow. Everyone is aware of that. It's a matter of public record. But she hit the nail on the head here. She's right. And the attorney for the LALB, Ms. Dow, would not have prosecuted this if she didn't see problems. But in the board choosing to, as Mr. Sims said, we could think something else. And in the board's bending over backwards to not find an auctioneer in violation of auction statutes. You talk about false and misleading reports to the public and not addressing the issue of the shield bidding. If she wanted to have reserves, she shouldn't have been forced to bid on her own items as a surrogate mechanism for having reserves. And that's what the judge said today. It's unacceptable. She should have been able to reduce those to reserves. And the LALB had a duty to state that she had not, that there was deception here, as Ms. Dow said there was. Instead, the LALB said, we find you guilty of nothing. And that has precluded her from filing a bond claim. Now, we got our victory today. Who knows what's going to happen in 19th JDC? Just savor the moment. I know you're happy. And,
I'm happy, but Robert, I realize that if it had not been for you and Reverend Freddie, I would have never gotten this far today.
Well,
but I really do appreciate y'all very, very much.
You're very welcome. And with that, we'll conclude our report. Again, the results from small claims court today. The judge awarded Miss Betty Story, and I may be off $1 or $2. I did not write the figure down, but $4,109 and some odd cents, in addition to the court cost, which she said should approximate $200. She asked Mr. Schmidt, how soon can you get that? And I want to commend the judge on this. She said she does not want to draft a judgment and have it recorded, because then it would be a matter of public record, and obviously then he would have to respond on his auctioneer renewal application that there is an active judgment against him. And so accordingly, she asked what time frame he could pay the $4,109 and some odd cents. Plus the $200-300 in court costs. He said he felt he could have it in 10 days. And so she said, I'm going to give you 15 days, which I believe she computed out to be November the 13th, if I remember right, in court. And she expects Ms. Story to report to the judge, to Judge O'Neill, that it has been paid. And she also asked Mr. Schmidt to drop by or mail a copy of the check evidencing that it has been paid. If that transpires, there will be no judgment. It will never enter into the public mortgage records that a judgment has ever been rendered against Mr. Smith. And I thought that was being very kind. And I think the judge was fair to both parties. And I think she gave good advice that, you know, she says everybody hates lawyers, but if you use them a little bit, you don't end up with, the kind of problems that we're having to deal with today. And I couldn't agree more with that. And that goes back to the webpage that we have here on LAPA about doing your due diligence on an auctioneer, because it's so much easier. The old saying about an ounce of prevention being worth a pound of cure, trust me, I think Miss Tori can tell you firsthand how much work it is to get that pound of cure. Now, she got it today, but boy, I'll bet you it would have been a whole lot nicer to just put in that ounce of prevention. Am I right?
It certainly would have been.
All righty. Well, Miss Tori, it's been a delight to have worked with you, and it was a delight to be with you today, and I'm so thrilled that things went your way today in court. And this is what our goal is as the Louisiana Association of Professional Auctioneers, to try to ensure that consumers, it's half of our goal. Reverend Phillips provides the consumer advocacy, the auctioneer advocacy. As you'll recall, he sought the $5 processing fee for license renewal. I, on the other hand, I'm strictly representing consumers, and I take that responsibility very, very seriously. Otherwise, I wouldn't be over here today. And it was nice for things to work out. Because the right thing happened in court today. The judge rendered the judgment that was reflective of what should have, at a minimum, arguably, Miss Tori was out even more because the whole issue about going into Canterbury House, and that was another $1,500. But at least this whole issue about believing that you can charge a consignor for buying back their own merchandise when you haven't explicitly put that in the contract is unacceptable. And I don't think any other judge would have rendered any differently, to be honest with you, because you're looking at the four corners of the documents, it's not there. So with that, I want to thank you for the opportunity to have visited with you both yesterday evening, and I want to especially thank you for the wonderful meal that I had last night at Steamboat Bill's or Bob's.
No, Steamboat Bill's.
Steamboat Bill's, right here in DeRidder. It was some of the best crawfish etouffee I've ever had, and I enjoyed the company of it. And let's see, it's about 2:20. I'll probably be back in Baton Rouge for the 6 o'clock news, and I believe there's a big debate coming on tonight involving our U.S. Senate. So let me go ahead and get on the road so I can catch that debate, and it was such a thrill to be with you, and I'm sure I'll see you again soon.
And tell my friend Freddie I said hello.
I will do it, and I know he's going to be thrilled to know this is the way it went. So,
thank you.
All right.